Yes, it has come from a high court in response to our notice.
मैं उसका conclusion कह रहे हैं पढ़ने का या preface
पढ़ लीजिएगा उनका लेटर क्या कह रहे हैं
जी
चले पढ़ लें
जी I can read out the conclusion first.
I was just trying to resolve this matter as quickly as possible, but yes, we can certainly read it. Please go ahead and read it.
Page 11 is the conclusion, but this letter obviously details certain facts and then the provisions, and then I can read out the conclusion if you mind. Conclusions. A.
Which page are you?
Page 11 of this note, sir, which is the additional note, but obviously the original is signed by the entire High Court. It's the full.
G.
Conclusions. A. Mandatory reporting with consequences for not reporting, followed by escalation to judicial contempt on inaction of the report. B. Promulgation of the judicial, within brackets, institutional code of conduct for all tiers of the judiciary. C. Revisions to the High Court rules. 1. To vest the functions of bench formation and case listing in the Administrative Committee in line with the Supreme Court Practice and Procedure Act 2023. 2. To eliminate misuse of administrative powers for targeted judicial outcomes. And 3. To reinvigorate the institution of the full court within the disciplines appropriate to a corporate body. D. Promulgation of code of conduct and ethics for the subordinate judiciary. E. Promulgation of rules for the conduct of judicial contempt under Article 2043 of the Constitution. F. Parliamentary hearings on reference by the full court as an institutional remedy adjunct to the contempt remedy. These are the conclusions. I may now read out the Lahore High Court, sir. A. It's CMA 3610, sir. Page 2, sir.
Relevant पढ़ लें सिर्फ. When the meeting was held,
ये Learned Attorney General page 7 में para 2 पढ़ लीजिए.
ये page 6 से शुरू होता है ना इनकी recommendations, वो पढ़े ना para 2 से शुरू होता है.
जी की बात करें. So page 7 onwards, sir.
Yes, no, page 6 से नीचे से paragraph 2 से शुरू होता है.
Paragraph 2, the participants thereafter turn by turn expressed their views in detail on the issue. It was concluded in the full court meeting as under.
Page 7.
One. All the judges of this court unanimously appreciate the above mentioned order, that is order dated 3/4/2024 in suo motu case number 1 of 2020 of the Honorable Supreme Court of Pakistan, whereby it is directed that the High Courts as well as
this is not really a proposal or suggestion.
Learned Attorney General para 2 से पढ़िए.
It is considered to be very encouraging for the judges of this court that the Honorable Supreme Court of Pakistan has passed the above mentioned order for the first time in the judicial history of this country to address the most sensitive and grave issue being faced by the judges of the superior courts as well as by the judges of the district judiciary.
इधर रुक जाइए. What are they saying? That this is a continuing and persistent phenomena.
My Lord. It was further observed that the principle of trichotomy of power is well entrenched in the Constitution, which guarantees judicial independence at the institutional level, including the individual judges. The constitutional norms dictate that government, its institutions and agencies must respect and observe the independence of the judiciary. The constitutional guarantee of independence of the judiciary ensures rule of law, realization of fundamental rights, and stability of the society. A functional democracy and civilian supremacy are effected and materialized in the presence of a vibrant, free, independent, and neutral judiciary. The freedom granted to the judges to decide cases according to their oath, uninfluenced by other factors, is crucial for equality of parties before the courts. 3. It was further unanimously resolved that no one should get an impression that there is any division or grouping in the judges of this court, Lahore High Court within brackets, on account of minor differences of opinions or dissenting notes given in the judgments, because the impression of division or grouping in the judiciary is intentionally highlighted by some individuals on the electronic, print, and social media for the benefit of the third party. Therefore, there should be a loud and clear message that all the judges of this court are standing united, and they also fully support the Honorable Chief Justice and Honorable Judges of the Supreme Court of Pakistan, who have been dealing with such like issues and other most sensitive matters of the country with courage and bravery.
And this is the paragraph which is very important, paragraph 4. Padhe.
It is also unanimously proposed that the Code of Conduct of the Judges of the Superior Judiciary and District Judiciary may be amended, and there should be a complete ban on the meetings of the judges with the members of the agencies, save in the cases of close blood relationships. It should be made mandatory for every judicial officer to immediately disclose to the district and sessions judge, the Chief Justice of the High Court, and to the Chief Justice of the Supreme Court of Pakistan if any attempt is made to interfere in his judicial work. A permanent cell may be constituted at the High Court and the Supreme Court level to process such reports, oblique complaints, and their decisions in accordance with the law. 5. The agencies, individuals involved in phone tapping.
Because in Balochistan, the lower judiciary did not have a code of conduct. Does the Lahore judiciary have it?
I think
High
they are
Court rules and orders
proposing.
में there is a conduct for district judiciary. जी, High Court
Rules and orders, Lahore High Court का मंगवाएं.
Code of conduct है district judiciary का पता नहीं. I think that's been adopted by some of the other high courts. You can read para 5.
Para 5. The agencies oblique individuals involved in phone tapping or audio oblique video recording etc. of the judges and their families be identified and proceeded against in accordance with the law. 6. If a judge of the High Court or District Judiciary is approached, intimidated or blackmailed by any member of the state agencies oblique executive, then the said judge, apart from taking oblique initiating other legal proceedings against the responsible person, may also initiate contempt proceedings against him, them, or he may proceed in the matter as envisaged under Section 228 PPC as the case may be. 7. The Chief Justice, the District and Sessions judge and the judge himself should immediately try to secure the CCTV camera recordings, phone recordings or other evidence which can be secured through modern devices, etc. in case any attempt or interference in the independence of judiciary is made by the executive oblique agencies. 8. There always remain more chances of interference in ATC, NAB and anti-corruption courts where sensitive matters are decided. Therefore, the High Court should be empowered to directly make, transfer oblique postings of the judges of the said court without the approval, interference of the federal oblique provincial government, and relevant provisions of law in this respect be directed to be amended accordingly.
Now, High Court also says about interference.
Yeah.
There is interference.
If the relevant judge of the High Court or the District Judiciary himself does not initiate contempt or other legal proceedings, in that case he may report the incident with full details to the Chief Justice or the District and Sessions Judge, as the case may be. On receipt of the report from a judge of the High Court, the Chief Justice shall constitute a suitable bench comprising of at least 5 senior judges of the court to hear and decide the said case. In the case of incident reported by a judge of the High Court, the matter shall also be brought into the notice of the Honorable Chief Justice of Pakistan, who may also take proper action on the said complaint if deemed necessary, provided the cognizance of the matter has already not been taken by the concerned judge himself or the High Court. Likewise, on receipt of report from a judge of the District Judiciary, the District and Sessions Judge, apart from taking any other legal action, shall proceed in the matter as envisaged under Section 228 PPC. He shall also report the matter to the Chief Justice of the High Court. Same procedure shall be adopted by the judges of special courts, ex-cadre courts. 10. Presumption of truth shall be attached to the complaint oblique affidavit of a judge. Moreover, as envisaged under Section 17(3) of the Contempt of Court Ordinance 2003, the complainant supported by the affidavit of the judge shall not be liable to be cross-examined by any party to the case. 11. If a complaint is made by the judge of the High Court or the District Judiciary on the above-mentioned issue, then it shall be ensured that the complainant is not unjustly victimized, as it happened in some cases in the recent past. 12. The burden to establish that the allegations leveled in the complaint of a judge were not true shall be on the respondent of the case, within brackets, executive oblique
The
state.
next para is important.
Next. 13. Large majority of the judges present in the meeting also observed with great concern that the interference of agencies / executive in the independence of judiciary is an open secret, and the earlier judgments of the Honorable Supreme Court of Pakistan to prevent the said interference have proved to be ineffective. Therefore, the judges of this court expect that the Honorable Supreme Court of Pakistan, in its final judgment in Suo Motu Case number 1 of 2024, may give a comprehensive mechanism to deal with the matters mentioned in paragraph number 13 of
Attorney
order.
General, is, to my mind, the essence of the Lahore High Court submission that this is an open secret that the independence of judiciary is being violated, and also that they now look up to this court to devise a mechanism because the earlier judgments have proved ineffective. So, in a way, the High Courts are actually beseeching the Supreme Court that this is high time that we put our foot down and do something about it.
I think one aspect should also be considered. There is or has been or may be interference from within. So I would say any kind of interference from any source. Okay, we will not countenance this interference. Yes, we must never countenance such interference. But can a Chief Justice call a judge and say, decide a case in this manner? You should
both independence from within,
Mr.
but
Attorney
also
General,
from without.
You should raise your finger to us as well. That if you want a true independent court, then the civil judge in Makran should be as powerful as the Chief Justice of Pakistan. How dare the Chief Justice of Pakistan interfere in his working? When we devise mechanisms for interference, such as monitoring judges, that is undermining the independence of the judiciary, in my opinion. When we mandate the role of intelligence agencies by constituting JITs, which are not provided for any law other than ATC laws, we undermine the independence of the judiciary. So all these suggestions should incorporate anyone. Otherwise, what we are saying is, once we assume a position of a judge, we are from the same society. We are from this community of lawyers that we come here. We may be good, we may be bad. The bad doesn't end when you are elevated. So interference of any kind, from any source, any phone call, that should also be equally for a judge, civil judge. Maybe that's more fearful than we are focusing on one particular thing on the executive. We should also call about self-accountability within the judiciary. And has there not been interference, and the greatest of interference from within and the highest court of the land? That's a matter of history. We can go into specific cases also.
So that's great.
To achieve certain results, certain things were said, certain things were done. So I had made it clear the very first day, I will never accept any interference from any source. And there has not been a single complaint since my assumption of this office to me or to the Registrar of the Supreme Court. We are now dealing with a past transaction. I would say very good. I commend that it is being done. But let's not then make it political and just say, for this period of time we are going to do it, and for that period of time let's close it, eyes to it. Let's either do it for all periods of time. That's also selective accountability and can become the worst kind of accountability in certain cases. So this, we have seen how these institutions have been manipulated. My thing from day one has been simply speak the truth. The past is the past. Let's grow up now. Let's at least acknowledge. If we are just going to cast blame on each other endlessly, there is no future for us. What has happened, we all know that. So it's an open secret. Tell us the dates when it happened. It's an open secret. Everyone uses this phrase. Give us instances. Yes, call me, I'll give you instances of how judiciary has been manipulated. I'll give you instances from this court itself. So let's be very clear about it. We want to tackle it. We will not be manipulated by being used by a political force, a political agency, or another intelligence agency, or any group of lawyers, or even the government of Pakistan, because this suits them in this particular juncture and something doesn't suit them. So when we put this, only we should put any source. Let it be said from any judge. I don't see, all the judges seem to, that is out. A registrar calls judges. I mean, shall be called for witness from among the lawyers. How many registrars have called judges to do what? There's another interference in the judiciary. Our presidents of the lower bar don't force their way into the judge's chamber. Is that not interference?
My lord, I think
strikes not another form of interference. So ये सारी बातें ख्याल में रखें.
I think I absolutely endorse the Honorable Chief Justice, but speaking for myself, you see, that's, if it is not happening, it's our internal weakness. That can be dealt with. But if the state becomes the aggressor against a judge, that is what all the high courts are highlighting. And that is a serious matter. The High Court of Lahore is endorsing what the Islamabad High Court has said. It is a continuing, and we all know that it is happening, and it has happened. And the judges, they fear reporting, because my learned Attorney General, since the last hearing, what has happened to a judge of the Islamabad High Court, his personal data, which cannot be accessed by a private person, was put on the social media.
Yes.
That is an intimidation. That is what affects a judge, and all those matters, mind you. My lord is on the bench, 2.5 hours of Judicial Commission's meeting. Each one of them was discussed. Even his green card was mentioned, and he was opposed by the judges from within and from outside because he was independent. Now, it is about independent judges. The internal problems, it is for us to sort out. It is the external, the state is to protect the judges and independence of judiciary. When it becomes the aggressor, which each high court is saying, that is what is the issue. And it is happening. It is a phenomena that has happened for the last 76 years. And this is what each high court is endorsing. It is happening today.
My lord, if I may,
Attorney General,
just a brief response.
Mr. Attorney General, just a second. I mean, let me just share how I look at this entire matter. You see, it is not about, the whole case is about independence of judiciary, be it within the judiciary or be it without judiciary. I think we cannot say that without, we give preference to this or the other. There cannot be any interference in the judiciary. We take off, the internal matters could be sorted out internally, as rightly said, but now we have this opportunity today in this case to settle the score and fix the matter for all times to come. I'm not too concerned about one particular incident. We're talking about a generic system, a code to be put in place today, that this should not happen. This should not happen from outside. This should not happen from inside. This is a golden opportunity that we have today to lay down a code that this firewall has to be built, that no more of this. So we can start off with the external pressures, we can come down to internal pressures, but we have to deal with it. These high courts have actually reached out to us to say this. These high courts have all these powers to do it themselves, but they haven't done it so far. The matter has landed on our table now today. अगर करना होता तो वो कर लेते, पिछले कितने सालों से वो कर लेते, सारी पावर्स कंटेम्प्ट की भी उनकी हैं, कर लेते. The question is, they haven't done it. The case has landed here as apex court. Could we just brush aside this thing and say, no, High Court, aap jab kar lo, jaake karo, hame kya pata kya karna hai, tum khud kar lo. We should empower the high courts. We are, by interfering in this matter, actually empowering the high courts, empowering the district judiciary, empowering the entire judiciary, and I don't think it's interference in any matter. It is actually empowering my courts in the country. So, as I see it, we need to sit down and lay down a code which is a clear firewall against all sorts of excesses. I'm not concerned about person A, B, C. My case is very clear. I just want to look at the system. The system has to be put in place that this cannot happen, and there has to be a mode and mechanism, which the high courts have very ably come up with a process that if something happens to a civil judge, what's the process? If something happens to the high court judge, what happens? High court is being empowered to take action. If high court doesn't do it, what does the Supreme Judicial Council do? Unless and until Supreme Judicial Council and all these forums, a mechanism is put in place, we're back to square one. So if this is an opportunity, we have 3 cases earlier.